California landlord-tenant laws include rent control policies, restrictions, limitations, and other miscellaneous policies. Now, while there are some general guidelines to follow in a rental agreement, some cities have their own regulations that you need to be cognizant of. So this is just a brief overview of California landlord-tenant law, and I'm going to explain the duties and rights of every party involved within the lease agreement. But as always, please keep in mind that I am not an attorney and this is not legal advice. If you need any additional information, consider talking to a real estate agent or a lawyer in your area. So generally, a lease agreement involves any oral or written agreement between a landlord and prospective tenants. Within this agreement, the landlord is allowing the tenants to inhabit their property in exchange for rent payments. Now, according to state laws, a landlord must disclose any information that may be important for the tenants to know. This is done to avoid any confusion or mistakes from either party. But overall, these are the most common things that are generally disclosed within a rent agreement. Parties involved in the rental agreement, a description of the property, the amount of rent due, the due date, the payment methods, the late fee policy, lease termination policy, eviction policies, security deposit policies, and any other additional mandatory disclosures, including things like utilities, pests, mold, and lead-based paint. So before diving into specifics, it's really important to know that both landlords and tenants have rights and responsibilities at the time of arranging a rental agreement. Now, this may vary depending on your local county and municipality, but these are generally the most common things. So according to California Civil Code 1940-1954.05, the landlord has the right to collect rent, withhold security deposits, return in case of property damage, and evictions in the case of agreement breaches. But on the other hand, these real estate laws require landlords to provide a safe and habitable dwelling unit for their tenants. This involves but is not limited to things like keeping utilities in good repair, having safe common areas, and pest control measures. And if there is any repair request from the tenant, the landlord must respond reasonably. In most cases, this reasonable time refers to 30 days since the repair was first requested. And if the landlord fails to provide repairs or refuses to do them, the tenant can exercise their right found in the repair and deduct remedy, in which the tenant is legally allowed to make the repairs themselves and deduct the costs from the next rent payments. So according to California law, tenants have the right to live in a safe, habitable rental unit. As well, they can sue the landlord for retaliation, they can withhold the rent for failure to provide essential services, recover attorney fees, and more. As for tenant responsibilities, these are the more common ones you're going to find in rental agreements. Keep the rental unit in safe and habitable conditions, keep themselves and their guests from disturbing neighbors or other tenants, make any small repairs that the property may need, pay rent on time, or comply with any additional rental agreement clauses. So a California landlord-tenant agreement needs to include details regarding how, when, and where those payments are going to be done. This will include any rules on late fees, bounce check fees, and the amount of written notice needed. If the tenant fails to pay on the day that a payment is due, landlords are legally allowed to charge a late fee only if the amount is reasonable. And while California law doesn't state anything specific about grace periods, a landlord might state one in their rental agreement. So landlords are allowed to charge an additional fee for bounce checks. According to California rental laws, these fees are $25 for the first bounce check and $35 for any bounce check that comes after. According to the repair and deduct remedy, tenants are allowed to partially withhold rent payments if the landlord fails or refuses to make a significant repair on the property. So follow me, this is going to get a little wordy. Landlords in California can increase the rent's price once every 12 months. Now, generally, landlords are required to give at least a 30 days notice to the tenant, but if the increase is greater than 10% of the lowest amount paid during the last 12 months, then landlords must give a 60-day notice. And when it comes to rent, the tenant must verify that they're appropriate and legal. You see, a landlord can't raise rent as a way to retaliate or as a discriminatory measure. This will actually allow the tenant to seek legal action and sue them. So these laws exist to try and solve the California housing crisis. According to the AB-1482 from the California Tenant Protection Act, any rent increase is capped at 5% plus inflation or 10% of the lowest price paid in the previous 12 months. These laws started back in January of 2020, and it's expected to last until January 2030. And it's also worth stating that these measures don't override those in cities that already have control laws. So cities like San Francisco, Los Angeles, and San Jose, you don't have to worry about it. According to California landlord-tenant law, security deposits are not required, but they're recommended to avoid any future issues. These deposits may be equal to 1 month's rent, 2 months' rent, or 3 months' rent for furnished apartments. Landlords are then required to give back the security deposit within 21 days of the tenant moving out. So what is the security deposit covering for you then? Well, I am glad you asked. The security deposit can be withheld if you're covering unpaid rent, cleaning or repairing expenses that came from extreme wear and tear from the tenant, but if the landlord refuses to return the security deposit within 21 days, they can be penalized. A landlord must not deduct other expenses from the security deposit besides unpaid rent or damage costs. As well, landlords who deduct expenses from the security deposit must provide an itemized list of the repairs they did with those funds. According to landlord-tenant laws, both parties involved in a rental property agreement may terminate the lease after it reaches its due date. So here's a brief overview of the amount of notice a tenant needs to be given. For a weekly lease, they need a 7-day notice. A monthly lease, 30 days, but it's not specified for quarterly and yearly leases. Now, on the other hand, a tenant may terminate their lease before the due date in the following cases: if they're going on active military duty, if the rental unit is uninhabitable, if the landlord is retaliating or harassing the tenant, or if there was an early termination clause in the agreement. While tenants' rights allow them to terminate the lease early, they still may need to pay the entire amount of the term. There's a lot of reasons a landlord may evict their tenant, but here are just some of the more common ones: breach of agreement, criminal activity, or failure to pay. In these cases, the landlord can give a 3-day notice to the tenant to either pay in full or quit. If the agreement wasn't written, a tenant might receive a federal standard of up to 3 months notice. However, at-will tenants are entitled to at least 30 days notice or 60 days notice if they've been renting for more than a year. So a landlord can enter their private property if they wish. However, they're required to give at least 24 hours notice before entering, unless it's an emergency measure, in which case they can enter without notice. Now, this 24 hours can be given in any way that the landlord sees fit, but on the other hand, both parties may schedule a visit during business hours to avoid problems. Let's dive a little bit more into the mandatory disclosures we talked about earlier. According to the California law, a landlord must provide 5 mandatory disclosures: a lead-based paint notice for homes built before 1978, bedbug infestations, mold, pest control measures, or use of utilities. Now, these laws may be confusing if you're renting out your unit for the first time, especially in this state where real estate law is so severely regulated. But I'm going to answer a few of the more frequently asked questions, and I hope this can help. No, a landlord is not allowed to change the locks of their rental unit as a way of evicting the tenant. However, if the tenant was a victim of assault or violence, then they can request that the landlord change the locks. Your tenant is entitled to stay on a sold rental unit until the lease term ends. So according to the Fair Housing Act laws, a landlord can't discriminate tenants based on their color, gender, religion, familial status, citizenship status, and more. Acts of discrimination include things like falsely denying the rental unit's availability, canceling the agreement arbitrarily, providing lower privileges to certain tenants, and more. So a court of law can hear payment cases involving a maximum amount of $10,000. Keep in mind that a landlord can only file up to 2 cases each year, and they may not amount to more than $2,500. Thank you so much for watching. I hope this answered all of your questions, and be sure to check out this video where I go a little bit more in depth with the eviction laws in California. Thank you so much for watching. Subscribe if you haven't already, and I will see you in the next one.